have judges who are changing court transcripts, directing their court reporters to change the transcripts so that certain things are not revealed on appeal. I think that's a type of corruption. I think that we have judges who make political decisions and do it willingly. I think that's a type of corruption because they're not bound by the law, and there's no reason for them to think they're bound by the law because there's no accountability in the current system. Now, you can appeal, I guess, if you've got A, the money, and B, the time, but understand it's going to cost you thousands and thousands and thousands of dollars to appeal, and maybe a year and a half of your time, and maybe then you'll finally get justice that you should have gotten that first day in court. So I see judges who absolutely hate men. I think that's a type of corruption. They exist, and if you're a man, you don't want to appear in front of them.
And is there evidence? I mean, is there a report that's been done that demonstrated this, or some sort of, compilation of evidence of this sort of thing, of records being changed, of hatred of men? I mean, where's the record of that?
Yeah. Well, understand, part of the problem is how much attorneys are going to say when they have to come back next week and appear in front of the same judge. There's a saying about you don't, if you aim to kill the king, you want to make sure you kill him. You don't want to just kind of injure him a little bit. And the problem is these judges are kings in their courtrooms, and so unless you're very confident that you can actually take them out one way, shape, form, or another, most attorneys are going to sit very quietly and say nothing.
Thank you, Mr. Wursel. Chief Magnuson, I've got a question here. The Board of Judicial Standard does not report all complaints. How would the public know the extent of corruption then?
They don't report all complaints because some of them are unfounded, some of them are relatively minor. I have heard Mr. Wursel make, again, a number of general statements. I've practiced law for 35 years. I've been in 40 counties in the last 2 years talking to judges and court staff, and the aspersions that he's casting are simply unfounded. I want to say that. Yeah, okay. Talk to the people.
Whoa. Right. Please.
Excuse me. I
apologize, Chief.
Well, I should apologize because I shouldn't make it this personal, but it.
No, this is not the way we do things here. We have panels here all the time. We've got a stack of questions. We're asking the tough questions that are coming up here. But please, just a little civility. Let's have a conversation and carry forward. Thank you.
There is a process for disciplining judges, and it works fairly well. It is like any other process that you have, a judicial process. It's run by people. There are good judges, there are bad judges, but you look at the ratings that the Minnesota judiciary gets. If there were rampant corruption, if there were gross malfeasance, you wouldn't have a system that handles 2 million cases a year and has an 80% satisfaction rating. I don't know what more to say.
Thank you, Chief. Ms. Walker, got a question here. I'm a recent female college graduate planning to attend law school. Historically, women do not run for elections, and when they do, they have trouble raising campaign funds. Would this present a particular challenge if we went to contested elections in terms of women either running for a judge seat or for holding on to their seat once they were in office?
Well, I mean, I think the obvious answer is yes. I'm not totally sure that that's accurate, but I think that this goes back to the whole idea of resources, and I'll connect it back to what Mr. Wursel just said about corruption also, which is I think that if there's nothing preventing corruption in either system, but it sounds like in order to unseat a judge in a contested election system, it sounds like what you'll need isn't just money for an appeal, but $3 million to run an election possibly. But in terms of getting people qualified, my concern is primarily with minority communities who the majority of the vast majority of minority attorneys and females are more likely to go into public interest law and less likely to make connections to big donors, private law firms, and are going to be disadvantaged in contested elections.
Thank you. Mr. Borgendale, if we continue to have elections, even retention elections, should we have a public financing system to cover the costs of campaigns?
I guess I'm probably opposed to that public financing. I think that it has become overly cumbersome relative to what is included, what is not included, and I'm just more supportive of just a private campaign financing.
Okay. Chief, do you have a view about that?
You know, I think the solution is not to put more money into judicial elections. I think we need to figure out a way to take the money out of it, address the qualifications of the judges on the merits, give the citizens meaningful information about the judge's performance, and let them decide, but not add more money.
Okay. Ms. Walker, do you have a view about that?
Again, I think public financing, I support public financing for other elections, but not for judicial elections. I think that the best solution is to maintain retention, merit selection, and it'll reduce spending all around.
Mr. Wursel, did I understand you before that you might be open to this, actually?
Oh, yeah, absolutely. Sure. We need more money in judicial elections, not less. I mean, when you go and flip over that ballot and you have no idea who the candidates are or why you should vote for them, it's symptomatic of the fact that judicial candidates have almost no money. So if they can't get a message out to you, why would you have the information? Now, in the past, the candidates were actually forbidden from personally soliciting campaign funds, so they couldn't raise the money, courtesy of our Minnesota Supreme Court in some of their rules. But that's the reason why these elections don't make sense to most of you. What we need to do is actually find a way to get more money into this and still maintain a judiciary that we can all respect. I suggest perhaps public financing.
Thank you. Chief, question here from a member of the Independence Party. Judges are the only people running for election who have the privilege of having the title incumbent after their name. Is that fair?
It's, yeah, I think it is. I think you need to have some basis to decide who you're going to vote for. I think that because we have, up until recently, not had party endorsements, that's a piece of information that the citizens should have. The Minnesota Supreme Court has affirmed that.
Thank you. Mr. Wursel, do you have a view about that?
Yeah, actually, this issue was in front of the Minnesota Supreme Court just 2 years ago, and I think most people in this room would recognize that the word incumbent does create an unfair advantage for the incumbent judge. The Minnesota Supreme Court didn't see it that way. I, this year, filed a federal lawsuit challenging the word incumbent. It's in front of the 8th Circuit Court of Appeals right now. We had oral argument, I think it was September 20th. If I'm successful, we will get the word incumbent struck off the ballot.
I'm curious about that. I mean, I'm curious about that. We just went through an election in which the word incumbent wasn't all that popular. I saw a number of candidates kind of obscuring whether they were incumbent or not. And this is a serious question.
Yeah.
Do you think there should be some other kind of information provided to voters? Is it not incumbent? Maybe it's some other kind of marker of quality or some other kind of label?
Yeah, party designation. That's what we need. I would suggest to you, I'm holding in my hands here a recent law review article from the Missouri Law Review entitled "Do Retention Elections Work?" And what they note is that when you have elections where there is very little information given, such as judicial elections, that one of the key means of getting information to voters would be a party designation. And it would give you a much more idea where these people stand, what they stand for.
And I'm just curious, when you think of a party designation, and you think of individuals, randomly being assigned a judge, and they go in front of a judge, let's say they're a business and they're going in front of a judge who's declared themselves to be a Democrat, who believes in regulation, who believes in higher taxes, perhaps something, clearly endorsed and campaigned for Mark Dayton, for instance.
Yeah.
Could you imagine, how would you imagine that, that litigant perceiving the handling they might get from that judge? Does that concern you about?
That's a wonderful question. Because if you're that litigant, wouldn't you prefer to know that walking into the courtroom? Because that judge may very well have been appointed by Mr. Dayton anyway, and might be a very strong Democrat, and you'll never know it because of the appointment process. But it became obvious to you, and in Minnesota law, you have a right to strike a judge, an absolute right, and so you could strike that judge and move on to the next courtroom and the next judge. So I think we're always better off having more information, not less, especially if you want to create a system where people get justice. Because there are judges I'm going to want to remove, whether it's because of their political background, the fact that they were involved in a car accident last week and I have a car accident case, whatever it is. There are judges you're going to want to remove. And what we need to do is use that ability to strike. Right now, I think under state law, you can strike one judge, and what we maybe need to do is expand that.
Thank you, Mr. Wursel.
No, not at all. I think that, one, I don't think party designation necessarily provides you more information on how a judicial candidate is performing. I think that taking a position on social issues, for instance, doesn't necessarily help people involved in the criminal justice system. But I would also say that Mr. Wilson mentioned that he thought more information was better, but that seems to also include the incumbency would be more information rather than less. But I also think that you're just not going to, party designation doesn't provide anyone with more information about a judge's evaluation.
Mr. Chief Magnuson, and I don't ask this question naively. I consider myself who's been following elections for a while in politics, and I follow the courts closely. So this is not a naive question. But help me think through the underlying concern that you hear from a lot of people that you really know the attitudes of a judge. I was talking recently, for instance, with a well-respected U.S. federal court judge about how the courts might handle the health care litigation that's now moving up through the courts. And what he said is, we just know who the Republican and Democratic judges are in the Supreme Court, and they'll get struck down. Is that a fair way to, because I see a little bit of that in Mr. Wursel's comments, that there really is a set of attitudes that come with the judge, and these are tending to override, meticulous attention to law, to the Constitution.
I think that there are two parts to your question. Do judges, when they take the bench, have attitudes and preconceptions? You bet. We are all products of our life experience. Do you want a system in place where if I'm appointed by a Democratic governor and I have a Democratic endorsement, and that's how I think I got elected, do you want that system in place so that when I make my rulings, I have to worry about keeping those people happy? Or do you want a system where no matter how I got on the bench, my allegiance is to get the right answer? My goal is to set aside, to the extent I humanly can, my biases and prejudices and the background that I came from. I have firsthand experience at that. And what you do is you try to put all that stuff behind you and decide the case on the law as you think is best. And, I know a lot of people were very surprised at some of the decisions that I wrote, thinking that I was the Republican choice on the bench. Well, I wasn't. I was a judge among 7 who tried to do the best I could in a system that incents me to have a political outlook overtly, to not try to put it away, to not try to put it aside is just wrong.